All right, let me introduce you to sales law. Now, this is a complicated area, so let me just walk you into it very carefully. Remember, we talked about contracts under common law. That you have to have four basic elements of an enforceable contract. It's got to be a legal deal. You got to have capacity. You have to have the agreement itself, offer and acceptance. You have to have consideration. Now, remember when we talked about the sources of American law, we talked about common law, and contract law is a product of common law. Court decisions have accumulated over time and given us this area of common law contracts. Now, common law can be modified by statute, and this is what we're going to be talking about with respect to sales and lease contracts. And this deals with a massive statute called the Uniform Commercial Code. This is confusing because it doesn't cover all commercial transactions. It's not uniform, and it's a default. I think that's very important for you to understand. The Uniform Commercial Code, for the most part, is a default, and what I mean by that is if you have a contract and you don't cover something in the contract, the statute, state statute, the Uniform Commercial Code is a state statute, will fill the gaps. So if you write a contract and you don't address, let's say, statute of limitations in a sales contract, the Uniform Commercial Code will say the statute of limitations is 4 years. Now, in your contract, if you're thinking, you can put in your contract statute of limitations 1 year. You can do that. And that trumps the Uniform Commercial Code. Now, there are some things you cannot alter, like you'll see under sales law, which is found in Uniform Commercial Code Article 2. Good faith and fair dealings are assumed in commercial transactions. And Article 2 refers to sales law. There are a number of other articles we're going to talk about. Again, this is a massive statute, and you need to be aware of how it works. And think of it as a default with certain exceptions. First of all, the question is, well, does the Uniform Commercial Code even apply, to a contract? And this boils down to whether it's a sale of goods or services. Services are not governed by the Uniform Commercial Code. Goods are, sale of goods. So what's a good? A good is essentially anything that's movable. You'll see this is defined in your book. It could be unborn animals, timber, stuff like that. There are some weird exceptions here, but anything that's movable. This podium, that's a good. Food is a good. So anything that's movable. I think it's best to realize that a good is not real property or anything affixed to real property. So that's the way I look at it. And everything else essentially is a good, except for real property and maybe real property and intellectual property. Those aren't viewed as goods. So how do you distinguish? Let's say I buy some carpeting. I go to a carpeting store and I order some carpeting. And part of the deal is installation. So I pay for both the good, the carpet itself, and the installation, which is labor, which is a service. What is the predominant purpose there? Well, it's the good. I wouldn't be buying the labor independently unless I have my own carpeting, right? If I did that, then it would be a service contract. But under that scenario I just gave you, where I go to a store, buy the carpeting, and labor is included, it's a sale of goods. Why does this make any difference in the world? Is that sales contracts have warranties. The law, the Uniform Commercial Code, imposes certain warranties. Warranties are guarantees. Now, these can be waived, and like everything else in the law, we have a rebuttable presumption. But that's at the end of the rainbow why you should even give a care about whether a contract is a sale of goods or services is this issue of warranties. And like you buy food at a fast food place, the assumption is that it's merchantable. You're buying it from a merchant. The assumption is that it's acceptable, and if you get sick from eating that food, that's a breach of what's called the implied warranty of merchantability. You can sue on that. That brings up another point. When you're looking at and analyzing a contract, not only do you ascertain whether it's a sale of goods, whether the predominant purpose is the sale of goods, you want to make sure up front you identify if there's a merchant involved. Now, merchant is defined in the Uniform Commercial Code and in your book. And this is a person who normally deals in the goods or has some expertise in that particular good. Important to understand the law of sales applies to both merchants and non-merchants. So if you have a neighbor who has a garage sale and they sell you, and they tell you they're selling you something, and they go, oh yeah, sure, you can use it for this purpose, and it ends up you end up being harmed or hurt, you can sue that person for a breach of an implied warranty of fitness for a particular purpose. So the UCC, again, a massive statute. Think of it as a default for most purposes, and it's intended to fill the gaps that you didn't cover in your contract. In your materials, I have a comparison. You'll see a comparison between common law and sales law. Important, very, very important for you to look at that and make your life a lot easier. But there are some key differences. I think the understanding you need to have is that the Uniform Commercial Code is a massive statute. It was intended to facilitate commercial transactions. So there are a number of things that the Uniform Commercial Code does, which modifies common law contracts to facilitate commercial transactions, whether it's sales. We're going to talk about checks and loans, negotiable instruments, things like that. So this is a massive statute that modified common law to facilitate commercial transactions. It has some provisions in there that are somewhat counterintuitive and may seem unfair. You'll see, for example, the idea of a merchant firm offer where you haven't even accepted an offer yet, but the merchant puts it in writing, signs it. That's good for, it's like an option contract in some ways, although there's no contract, but you can go back and hold the merchant to that merchant firm offer. There are some other weird exceptions that the Uniform Commercial Code makes to common law contracts, again, to facilitate commercial transactions. One that's important from the upfront is that the offer can be indefinite. Remember, under common law contracts, the offer has to be definite. Under sales law, the UCC, a lot of flexibility. You have to have a price, even a quantity can be loose. The idea that the parties are going to behave in good faith, that's one of the things the UCC mandates. You can't waive that the parties behave in good faith and with the objective of getting the deal done. Now, like with a lot of statutes, the legislature is not going to pass a statute unless it's intended to alleviate some problem. And the problem with common law contracts, it's required very definite, very hard to modify under common law. You had to go through all the consideration, all this other stuff. So it was just too viewed as too limiting to commercial transactions. But keep in mind, there are special rules for merchants that you'll see that are somewhat maybe counterintuitive. And in the law of sales, we talk about the concept of title. When does title transfer? And normally it transfers with delivery of the goods, right? But not necessarily. You'll see that there's a thing called documents of title where the goods are delivered to a warehouse and you get a receipt. It's called a warehouse receipt. And you get the receipt, it's a document, it looks like a contract, then you bear the risk of loss. If the warehouse burns down, your problem. Likewise, shipment contracts, you'll see this is discussed in your book. Typically, with a shipment contract, you order goods shipped from another state. You bear the risk of loss if it's damaged in transit. Of course, if you have a commercial carrier, they're going to bear some, if not all of the loss as well. But if you order goods, just realize the default under the UCC Article 2 is it's a shipment contract, that the buyer is going to be responsible for the risk of loss. and that's called a shipment contract. If you're smart and you write the contract, you could make it a destination contract where the seller is going to be responsible. You'll see there are certain remedies that are apropos depending on the where the goods are. If they are still with the seller, if they're in transit, if they're with the buyer. But I will say that acceptance of the goods is a critical event, because from that flows taxation. Your remedies change dramatically, because then you're left to breach of contract and warranty. If you reject the goods, and under the UCC, a buyer has the right to reject goods, and within a reasonable period of time. And a smart buyer will inspect the goods and reject them if there's a problem, because otherwise you're left to these other far more difficult remedies. Statute of frauds and some exceptions. Remember, statute of frauds is a statute designed to prevent fraud. And we talked about that in the context of common law contracts. With respect to real property contracts, by their terms cannot be performed within 1 year. If you're going to be a guarantor in a contract, that kind of thing. Likewise, in the law of sales, there's a provision that concerns the statute of frauds and a number of exceptions, like specially manufactured goods, etc. They're normally under the UCC law of sales, any sale of goods over $500 has to have some writing. Now, the writing requirement is very loose. Again, an example of how it modified common law contract, where you have to have some very more stringent requirements under common law contracts. Again, why this makes a difference at all, I think for most people, is the issue of warranties. Express warranties, those can be oral, they can be written, they're very hard to waive. Implied warranties, those are things that the Uniform Commercial Code implies in sales contracts. The biggies, there's several, but the biggies for you to know are implied warranty of merchantability. That's where a merchant, again, this is why you need to distinguish a special rule for a merchant. Where a merchant sells you something, could be food, could be a car, could be whatever, and it ends up defective or not fit for human consumption. Those are implied warranties of merchantability, and if you're injured, you have a remedy. Now again, there are other statutes that can affect this. There's ways that the seller can waive some, but not all, of the implied warranties. And you'll see this is discussed in your book. Typically, for example, the implied warranty of merchantability, it specifically has to say that they're waiving the implied warranty of merchantability. I'm sure you've seen this if you've been to a used car lot, and on the window they'll say "as is." They put that in there because they're trying to waive all these implied warranties. Important for you to understand this as a consumer and as a business person.